I'm a big YouTuber.
I literally cover court cases for a living.
I'm gonna give you my ID.
I cover the court cases for a living.
Yeah, what up, y'all? Welcome to Crown TV. I am the Crown Prince, aka Mr. Anti-Goofy. You know what not to do in my comments. Shout out to the Anti-Goofy gang. We on our way to 20,000. We in the building. If you want to donate to the channel and you really gang, instead of the super chat, hit up the Cash App gang. Alright, y'all, so AR Ab has just scored a huge win in this trial that's coming up, and in order to show y'all how huge it is, I have to give y'all a little bit of backstory. But the win is that no social media posts or rap videos will be allowed to be introduced as evidence at trial. These social media posts and rap videos that will not be admitted are completely damning. I'm talking about some of the most self-incriminating stuff you've probably ever seen. Now, I want to give y'all a little bit of backstory so I can show y'all exactly what I'm talking about. Now, a while back, the government put in to have these videos and these social media posts admitted, and the order was granted. So I'm going to take y'all through that so y'all can see exactly what was being admitted, and then I'm going to show y'all what happened and what led to it being not admissible. Now, this is from the government's original motion to have these social media posts and rap videos admitted, where they outline and lay out everything that's in them and why it's important to the case. We starting with part 2 here for the sake of time. I just want to give y'all the important stuff. It says the government is seeking to admit social media posts falling into 2 categories. Rap videos posted to, among others, Instagram, in which the defendant Abdul West, we're talking about AR Ab, communicated threats of violence, and which demonstrates West's power and authority within OBH. And 2, social media posts documenting the drug trafficking activities of members of OBH. Now I'm skipping down to the second part of part A to avoid the legal mumbo jumbo. Y'all know y'all can hit me up to get these documents if y'all want. It says, as part of the conspiracy charged in this case, the defendants are accused of using threats and violence to facilitate their drug trafficking. Indeed, this use of threats and violence is specifically pled in the indictment. Social media posts which communicate threats of violence by members of OBH therefore fall within both categories of intrinsic evidence as set forth in green. Now this is where they lay it out. As example of such a post, after defendant Dontez Stewart murdered a rival of OBH, West bragged in a rap video posted to social media that he sent Taz to take his head. Taz is Dontez Stewart's street's name. Notably, the lyrics to the rap video were found on one of West's phones seized during the course of the investigation and was dated October 18, 2017, 4 days after the murder of Robert Johnson. This is damning evidence, and it directly proves that West and in turn OBH utilized threats of violence to maintain their drug trade. The defendants cannot claim that West's raps were part of any performance or persona either. In them, he identifies specific and actual acts of violence, including murders, and related those acts of violence to OBH. Even if the indictment contained no allegations or threats of violence, West's rap videos would still be intrinsic to the charged offenses because they specifically facilitate the commission of the crimes charged in the indictment, and that they conveyed threats to anyone who might challenge OBH's drug trafficking operation. Additionally, after law enforcement executed a search warrant at a stash house operated by OBH, during which they seized 10 kilograms of cocaine and arrested one of the members of the drug trafficking organization, West posted a rap video to the social media site Instagram. In that Instagram video, posted just 4 days after law enforcement execution of the search warrant, West complained that law enforcement took 10 of them, a reference to the 10 kilograms of cocaine seized. West further states, $250,000 lost, got a broke heart, and they snatched my dog, that's the worst part. One rat destroy everything you work for. I pray to God that he don't tell him who he worked for. This is clearly a reference to the arrest and possible cooperation of defendant Hoover, who was arrested at the time of the seizure. Wes's raps were not just performances, they are direct evidence of Wes's association with other members of the drug trafficking organization, his involvement in charged crimes, and his admissions of guilt. Now, that is just to show how damning these posts would actually be at this trial. Now, the government's motion was originally granted on the basis that obviously these social media posts and rap videos are directly related to these crimes that AR-AB and others are charged with. Now, this defendant, who goes by the name of Richard Hoover, has his trial severed from the others. We see that in a lot of cases. We saw that in the case with Irv Gotti and Supreme, where he wanted his trial separate because his charges were different. If you got me in here for money laundering, I don't want to be on the same trial with people you have facing murder charges. And that's based on the way that it looks to a jury. So this defendant, Richard Hoover, has his trial severed from the others. And he ended up winning on this motion. So a few days ago, AR-AB filed what is called a motion of joinder. And what that means in short is that I would like to join whatever motion this person put in that was granted, and therefore that will be granted for me also. So today we learn that AB's motion is granted, and it reads like this. And now this day of, and you can see at the top, this was filed on 9/20/19. It says, upon consideration of defendant Abdul Ibrahim West's motion to join co-defendant Hoover's response to the government's motion in limine to admit social media posts, it is hereby ordered that the motion is granted. The government is prohibited from introducing any rap videos or social media posts at trial by the court. So this is a huge win for AR-AB considering. And we don't know anything yet about Vlad TV or any of that other stuff. We haven't heard anything about that. But this is a win. There is still a lot of what I think is unsurmountable evidence in this case, but I am still looking through paperwork after the original indictment to see what was deemed admissible or inadmissible up until this point. I will update y'all further on that as I get to it. Y'all let me know what y'all think about this in the comments. Like, comment, subscribe if you are not a goofy. If you are a goofy, you know the rules, man. It's the Crown Prince. I'm out, y'all.